क्या हो गया कि affected the appellant therefore but otherwise the beginning is very you can't discuss. Already having that number for the state. You could be the pain reason that they were having say 60 minutes. Yeah. This place just reading they go to 70 persons. They want to increase the database, then they have to work outside. Can't say it.
Maybe the lordship. Lordship, I beg to Petitioner item number 30, lordship 30 lordship.
30.
30
What
lordship.
do you want, sir?
Lordship, actually lordship by opposite party lordship, yesterday lordship last occasion he filed a opposition lordship, opposition. I have to file reply lordship. Lordship, he is also there lordship, he has no consent, has consent lordship. May paid for lordship may be taken up after 2 weeks lordship. In the meantime, I'll file reply.
Is it okay? As jointly paid list on in April
Any day after 2 weeks lordship.
after 2 weeks.
Yes, lordship maybe.
The date may be fixed.
No matter.
If you want a date, then it will have to go. Maybe on 28th March, 29th March, after hearing.
May I please, Lord? As it is item number 23
Yes, please.
and as well as item number 39, my lord. In this case, I am appearing on behalf of my friend, my lord, M. Mahanta. Yesterday, we have filed a mention slip, my lord. The matter may be taken, kindly taken up after 2 weeks, my lord.
Any objection from the other side?
No, my lord, I have placed the
Very well. As paid by council Shri so and so. Council Shri so and so has circulated an adjournment slip. The other side has no objection. Re-notify after 2 weeks.
item 23 and 39.
More space than the original job. Lead is the remaining part incorporated in form issue at the end of the job. Honestly,
Yes.
My lord, notice of served sent to the opposite party by registered post, but it is not the time not served upon the respondent, my lord. By last order, we will directed to make inquiry in the post office. We have inquired, but no notice is issued, my lord. So the matter will disturb tomorrow for passing an order for taking place state for service of notice.
This tomorrow.
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 So listing first.
In order.
Service has not been completed.
Your Honor, permit me to mention item number 4 to 10.
Yes.
I moved an adjournment slip in this matter with the consent of the other side, Your Honor. The counsel is actually not in town. The arguing counsel for the respondents is not in town. So I'm only requesting
Any objection? Not.
a date may be fixed, Your Honor. That's
Council for the respondent has circulated an adjournment slip. Shri KL does not have any objection. Re-notify on. May में जाएगा. This goes in May, 3rd May.
Not.
3rd May, Your Honor. Deeply obliged.
March and April, it takes too many days.
Lordship, item number 11 to 14, these are the income tax appeals.
Yes.
Lordship, Honorable Supreme Court had one of the similar point, Lordship, that is fixed for judgment. I pray this matter may be taken up to 3 weeks. I have taken consent.
Shri KL states that Honorable Supreme Court is seized of matters involving identical controversy. And thus these appeals may be adjourned, deferred by 8 weeks, awaiting outcome of the aforesaid litigation, not ordered accordingly.
Much okay.
May it please your lordship. Lordship, I beg to pay for listing of an writ appeal, lordship, on 10th, your lordship.
Okay, what is the urgency, gentlemen?
Lordship, they may file contempt, lordship, and we are already 19 days late, lordship.
It is beyond limitation.
Yes, your lordship.
All right, get it listed on 10th.
Obliged, lordship.
May I please, your lordship? I beg to mention item number 70, lordship. We have submitted.
17.
Yes, lordship.
Counsel, you are for the respondent.
Yes, lordship.
Counsel for the respondent has circulated an adjournment slip. The other side has no objection. List after 4 weeks.
Obliged.
May it please, my lord. My lord, I beg to mention item number 18, my lord. I've circulated an adjournment memo.
Same order, 4 weeks.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 36 and 37 of daily list, and I have taken the consent of the other side.
You have not circulated an adjournment slip, madam.
Lordship,
You are required to do so anyhow. Why do you want these are writ petitions of 2013?
Lordship, my senior is out of station due to some medical
What is the
emergency.
controversy involved?
These are reservation matters, Lordship.
Accelerated from.
ACP, okay. All right. Counsel for the petitioners, place for time. Re-notify for hearing after 6 weeks.
Lordship, I am for the respondent.
For the
State
respondent.
respondent.
All right. The petitioners, have they been informed?
Yes, Lordship.
Gentlemen, do you have any objection? No, man. The counsel for the petitioner does not object to the prayer for adjournment. Released after 6 weeks.
Obliged.
May I please your lordship? Lordship, I beg to mention item number 24 for adjournment, as my senior Mr. S.K. Mehdi is out of station.
I am for the respondent, my lord.
Then counsel for the respondents, petitioners, Union of India,
Yes, Lord.
praise for time. The other side has no objection.
No.
List
Date
after 4
may
weeks.
be fixed, lordship.
Then the date goes in May, gentlemen, not before that. 2nd May.
Obliged, Lord.
Obliged.
May I please your lordship? Lordship, I beg to, with the consent of other party, I beg to mention item number 2 of daily list, lordship. Lordship, it may come in the next week, lordship.
When you have not circulated any adjournment slip, what do you
Lordship,
expect that the prayer will be allowed?
Lordship, today only we have come to know that other side have filed a caveat in this matter, lordship, and the file of the caveat that was received by us is not numbered properly, lordship.
Is there a caveat? Not with the file. Then counsel, you are Mr. Gupta,
Lordship, I am appearing on behalf of Mr. Gupta.
counsel Shri so and so, appearing for Shri H. Gupta. Submits that he has been provided copy of the caveat and the other side is not represented. Registered to check and report, re-notify the matter after 1 week.
Obliged, lordship.
Item number 1 of daily list for motion.
By order, melody, instruction has to be obtained, melody. Regarding this, melody, affixing the notice under subsection 4 of section 13 of the SRPC Act, melody. So where the property is concerned, this property is never placed with the bank. The property
It was not never placed.
never placed, but the property, whatever the description is there, is other than the property, whichever melody they affix the notice, melody. The property schedule that was placed with the bank for the security of the loan amount of 15 lakhs and my cash credit and another term.
What is your stand, sir?
My lord,
You are required to,
that land is, my lord, fall under erosion. This is the, my lord, by act of God.
that's a different thing.
Yes, ma'am.
You say that the property in question was never subject matter of being
No,
mortgaged.
I am not on.
That, for that, they have to make a statement.
But
Your Lordship, we have not found any discrepancies in our mortgage property as well as the property which we have taken under the policy.
Say so on affidavit. Then we'll relegate them to the DRT,
Yes,
plain and simple. Why have you not filed the affidavit? You were required to do so by order dated 8th February.
Your Lordship, we will file it, Your Lordship.
And counsel for the respondent prays for and is granted 4 weeks time to file counter affidavit. Interim order shall continue till next date of hearing. List up 4 weeks.
Master, please.
Item number 3 for admission.
May I please, Your Lordship? Your Lordship, wide order dated 9/2/2023. We have been given a last chance to hand over the possession or to refund back of the money. And Your Lordship, as we have already obtained the Deputy Commissioner's order for taking the physical possession, but due to some administration problems, we could not able to carry out the same. So I pray for another 3 weeks in this matter, if Your Lordship allows.
3 weeks.
Yes,
A
sir.
very casual statement, Mr. Counsel.
No, Your Lordship, actually, we have.
When was the auction sale made?
That was in the year of 2016, Your Lordship.
16.
Yes, sir.
So how do you plan to compensate the buyer for this 7 years of illegal deprivation of enjoying the property which he has purchased?
Your Lordship, that question is another, again, it will open a new case, Your Lordship. That because that the writ petitioner has come out very lately. And earlier he has already accepted the possession on the sale certificate itself. But
That is a
later
paper
on-
possession, sir.
Yes, Your Lordship. And thereafter, the land is a vacant land at that particular point of time.
Hmm.
So in that scenario, we need not to move further. But since the writ petition has been filed, so we have taken steps, and so Your Lordship may kindly allow us.
You're handing over the land or the money?
Yeah, land, Your Lordship, because we have already taken all orders, necessary orders and everything.
What is the status of the suit?
Suit in suit, Your Lordship, my order 7 rule 11 petition has been rejected. And we are in a process to file a CRP against that rejection.
No, so essentially you're waiting for orders of the civil court.
No, Your Lordship, we are not waiting, Your Lordship. We have already taken orders, Your Lordship, in spite of pendency of the suit. And on the last occasion, we have placed, Your Lordship, on.
One more last opportunity.
Saiwala,
My lord, I'm very daunted by because if I get the land, why not that?
The land must be at prime. That is my needs.
Mr. M. Sharma, learned counsel for the respondent bank, submits that further 3 weeks' time is necessary to take all steps for handing over the land in question to the petitioner. Mr. Sahiwala, learned senior counsel appearing for the petitioner, submits that the opportunity granted should be the last opportunity. Full stop. It is seen that earlier several opportunities have been granted to the bank to take necessary steps for handing over the land. Purely in the interest of justice, we adjourn the matter for a period of 3 weeks.
Hello.
Enabling the bank to take all necessary steps for handing over the land.
Fixed date. 2nd March. 4 weeks.
Second,
2nd March.
April.
2nd April.
No, third, fourth,
3rd
third,
April.
third April.
Hello.
Item number 15.
This is that.
May I please to Lordship? Lordship, I'm appearing on behalf of Mr. A.R. Bhuya. He is on lag at another court. So your Lordship may please pass over the matter for the pending.
There are other connected appeals. What has happened to those? Can you provide the numbers so that we can bunch them together?
One type.
Item 15, my lord. No, my lord. Item 15 is Samim Akhtar Subhani. That relates to the Madrasa TET qualified candidates who are not being allowed to participate
Yes.
in the regular selection
But
process.
there were more than 100 petitions which are filed.
My lord,
So
no,
there must have been more
in this
appeals.
in this matter, my lord, this is the
This is
only
only appeal.
appeal. Yes, this is the only appeal. The item 16, we have got connected appeals.
Yes. You want it to be taken up today?
Yes, yes, Lordship.
Password.
Item number 16.
This connected appeal is 186 of 2022. Fixed on 28th of
Fixed of
March.
28th of March, Lordship.
Grace mark. These are the.
Why do we need to wait for that appeal? We'll decide this one. The same judgment would follow.
Because that was an appeal by the state also.
Okay, there's an appeal by state.
and
Then we
that
need
was
to
an-
hear it together.
That is the appeal by the state. This is an appeal by the aggrieved.
Then we need to hear it together.
Minus.
It is submitted at the bar that this matter may be listed along with writ appeal number
186 of 2022.
186 of 2022, which is stated to be fixed on
28th of March.
28th of March, 2022.
26. इसमें फिर क्या है कि ये देखिए cost title हम सुबह this can be in form of in the appendix or a schedule. You will save so many pages
Correct.
in every set.
Correct.
That makes use them. We'll amend the rule of order. We'll do that.
My lord, in
In the
the
meantime, why don't you
we have
think
done.
of
My lord,
undertaking an exercise?
my lord,
If you want to grant grace marks,
my lord.
do it across the board. There will be no heartburn at all. You require appropriate number of candidates.
My lord.
That is why this exercise has been done.
My lord.
So you do it across the board. Why a person who has cleared the TET examination on his own merit,
Right.
he should feel that the others, they are coming on par merely because you are giving them grace.
My lord, they would not come at par because, my lord, it is.
Irrespective, the number of marks will be reflected somewhere.
My lord, the grace marks that we had given would not be taken into account.
That is
when
all
we are-
right. That is all right.
assessing
Firstly,
the
there is no provision. There is no provision for grant of grace marks. Secondly, if you do so, why do you discriminate amongst those who have cleared? You just contemplate. AG Saab, we are asking you a question that if at all this grace marks business is to be approved, why shouldn't it be done for all? You have conducted this exercise, undertaken this exercise on the assumption that you don't have sufficient number of candidates, that is twice the number of vacancies. If you give grace marks to even those who have cleared the examination, that is the heartburn which they have portrayed, that supposing they are given grace marks in part 1, part 2, maybe some candidates might even go higher than those who have already cleared on their own merit. So what happens if you give the grace marks across the board?
We have just given a very limited number of grace marks, Lordship, just to clear them.
To
And
clear
that is number
So,
one.
If you give marks to those, grace marks to those who have already cleared, the number will remain the same. The number of candidates which you want to bring in, they will be brought in otherwise also. But those people who have already they cleared the TET examination, they will not have that heartburn. That these people, even though not qualified, they have been given grace marks and now they are on the same pedestal.
It is just a qualifying exam. That is number one.
Understood,
That is
understood.
number one, Lordship. There is not sufficient number of TET qualified candidates. So to increase it,
So
otherwise it would have been much less.
understood, sir. But if you want to give the grace marks, why don't you give it to all? So these people who are left out because of slight deficiency,
Slight
they
deficit.
will be brought in, but at the same time, who have cleared. This is just an indulgence which you are granting.
Yes,
While
Lordship.
doing so, Can you differentiate among the same set of persons?
It is, there are two parts, Lord. One is the qualifying exam, and this is a recruitment process.
We are not talking of the recruitment process.
In
We are
recruitment, there is no
talking
grace mark,
Only of TET.
only of
This is
that,
the only grievance.
only grievance they have for the TET. But they did not challenge it at that point of time. It was given 1 year earlier. 1 year later, when the recruitment advertisement was issued, then only they came up. Now, in the recruitment process, there is no scope of any giving any grace mark.
No, we are not talking of that, sir. You have not given any grace marks in the recruitment process.
Not.
That is the grace marks you have given to
For
TET
TET.
qualified, TET exam, those persons who appeared in TET and did not secure the 60% marks
Lordship.
in order to bring in sufficient number of candidates so as to make
To
it twice
into the
the
competition.
number of vacancies.
Lord.
But the entire heartburn, you just think of it, will be addressed if you give these grace marks to those who you want to bring in and those who are already there.
Lord.
They will just gain 5 marks more. That's all.
Lord, just one. While we are tabulating the marks in the recruitment process, we are not considering the grace marks.
That statement we have noted, that you made that statement. But still they say that why those persons who are not, as a matter of fact, clearing the examination on their own merit, you are trying to bring them up by giving them this indulgence, discriminating amongst the people who have qualified on their own merit.
That can be one way of balancing it. We
Just think of it.
yes, Lordship.
If that is done, probably
Yes.
this entire litigation will be put to
In
rest.
this particular judgment, Lordship, all the parties have come under.
So,
this is
yeah,
one
just
unique
think of it.
judgment.
Just think of it.
Lordship,
You give
definitely, that will be
five
one
marks
balancing. We
across the
never
board.
thought it from that point of view, Lordship.
Yes,
List,
Other-
list accordingly. No?
we'll list it on the date your appeal is listed, state appeal.
Yes,
State
Lordship. The other cases,
28 March. Yes.
all parties have filed appeal against the same.
So if you take that decision, probably we'll not.
No, if required, Lordship, will take it, no difficulty, and because there are still dearth of candidates.
Then
No, you can.
you'll get
you-
sufficient
you
number
can
of
just,
candidates then.
You can just reflect on what my lord has said,
Yes.
and then we can take up the matter on the
No,
next.
no
written
difficulty, Lordship. Government is open to it, Lordship. Because we have a relaxation power, we exercise the relaxation power.
So if the relaxation is to be given, it can't be selective.
To one category, yes, Lordship, we have given, by other category at the same time may have,
Yes.
as Lordship has rightly said, they may have, they are having heartburn. We'll definitely look into it, Lord.
As jointly paid list on 28 March along with connected appeal number so and so.
Deeply obliged.
Matter number 19.
May I please your lordships. This matter pertains to non-confidence motion accepted by the member of the Anipur GP, my lord, against its president, my lord. The resolution, my lord, will find at page 38 and 39, my lord. Against the resolution, my lord, the appellant has approached this honorable court, my lord. Learned single judge has come to the conclusion that section 15 was not followed, my lord, and accordingly the impugned no confidence motion was set aside, my lord, which my lord will find at page 87. We are not on that, my lord. As far as the resolution is concerned, my lord, it has already been set aside, my lord. We are on the part 2, my lord, as far as the direction given by the honorable learned single judge, my lord. The direction was to go for a fresh meeting, my lord, within next 15 days, my lord. Squarely covering my case, my lord, there is a writ appeal preferred by number 378/2022, my lord. My lord justice was part of that, my lord. And by that order, my lord, learned single judge order kept in abeyance on 9/12/2022, my lord. And the writ appeal number is
Still pending.
still pending, my
So
lord.
we'll connect both the matters.
I'm deeply
Get
obliged.
them together.
My lord, what happened, my lord? My humble prayer is that I am appearing for the respondent number 8 to 16 in the present appeal, my lord. And I have not filed KBA, though I have not filed KBA today, I am appearing, but I am filing. My lord, lordship may take up the matter day after tomorrow. What happened in this case, after considering everything and prayer of the appeal, my lord, the honorable single judge has was pleased to allow his petition to the my lord position extent that my lord, setting aside the order passed by the my lord, it's a democratic process, my lord.
He is now what he is trying to find within the process. So thereafter tomorrow, a copy of the record may be served on
The democratic process was tainted with illegality.
Yes, ma'am.
So the consequence, as a matter of fact,
Yes.
this scope of revival of the no confidence motion, you will have to address the court on that.
Yes, ma'am.
For that purpose, another writ appeal is entertained
Yes.
and there is a stay operating.
Yes.
We'll hear both the matters together.
No, my lord, what happened, my lord? This is a process, my lord, the members involved, my lord.
Why you are so apprehensive?
My lord.
Will
that
there
is
be
what-
horse trading in the meantime?
Yes, that is what. That is
So all right, let there be.
So,
That is the democratic process.
Take up the matter day after tomorrow, my lord. Day after tomorrow, a copy of.
When the other appeal is coming up,
The instruction was, my lord, it was admitted on 19th, my lord. Instruction what my lord will find at page 5, my lord.
Facts, other case may be different, my lord.
Till returnable date, my lord.
That is.
And the issue returnable date was 18/1/2023, my lord.
That fact.
Till then, my lord.
That fact may be different, my lord. So we'll go through the appeal, my lord, it will be day after tomorrow, my lord, in any case. My lord, it's a democratic process. We'll
yes,
follow
we
the-
understand, sir, we understand.
Yes, my lord.
Then we should simply set aside the second part of it and say that you are free to move a fresh corner
That is
motion.
what, my lord, Honorable Sindhu Judge has made.
We'll leave you at liberty to move a fresh no confidence motion as per the Panchayat Raj Act.
I'm deeply
Yes,
obliged.
That will be there. You will not be able to do it for another 6 months.
My lord. Page 88, lordship kindly. Last, lordship kindly. That is what, my lord, Honorable Single Judge has taken care of all these things, my lord, while disposing of the, my lord, writ petition. Page 88, my lord.
Mr. Counsel, the division bench judgment in Karun Kanti,
Yes, my lord.
that is precisely in lines of what the learned single judge has directed.
Yes, my lord.
So even if there is a stay, assuming by the division bench, ultimately, if there is a concluded precedent of this court,
Yes.
why should we take a different view?
Yes, my lord.
It's not a different view, my lord. All together, my lord, the all judgment has been cited in this, my lord, can come to page number 87, my lord.
Yes, para
Except
21.
Paragraph
8,
20 makes everything clear, my lord.
Yes, hold on, sir. Hold on, sir.
All right.
87, my lord.
Yes,
On the same issue, my lord, till that first paragraph is about the no confidence motion, my lord. My
Yes.
single has come to the opinion that my section 15 was not followed.
yes.
Thereafter, my lord, the direction was given, my lord. My lord, my respectful prayer would allow me to read, my lord. This court of the view that the similar direction is called in the case in hand because of the motion of no confidence is not lost till survive the new fact and was taken up for the consideration in illegally conveyed special meeting on 17/10, my lord. It is therefore directed that the petitioner of the president and Anipur Gaon Panchayat shall convene a special meeting within 15 days, my lord. So exactly on this point, my lord, the writ appeal was preferred, my lord. And the writ appeal
What
was,
is the, Mr. Counsel, what is the law laid down in Karun Kanti Malakar's case? please?
yes, my lord, I'm coming on that, my lord.
Yes.
It is, my lord will find Karun Kanti,
And Molikshur Rahman, Moklishur Rahman.
yes, Moklishur Rahman, it was given that, my lord, proceedings of no confidence motion were held to be vitiated and not sustainable in law. However, the setting aside of the resolution, the director was given to hold a special meeting within 14 days, my lord. In that case, my lord, thereafter in paragraph 22, my lord, upon setting aside the resolution of no confidence motion, my lord, and directing it to be null and void, the court will be failing its duties in exercise power under Article 226, my lord. My lord, one part was setting aside the resolution, my lord. Thereafter, whether my lord can go for further direction to convey, my lord. Once this resolution is adopted, my lord, not following section 15, my lord, resolution.
That is
goes, my
what the division bench has held, that we can give that direction to continue the motion
Yes.
by removing the illegalities.
From where it stands, my lord.
lord.
And he is entitled within 15 days. That is the act provides for, my.
Face the democratic process. What is the
Once
problem? You have to have that opportunity
My lord,
of buying back the confidence of the
That is
Once-
the other members.
once-
the act
once-
provides for-
once,
Section 15, my lord.
Just hold on, sir. You have not called you upon as yet.
my respectful prayer will be, my lord, this direction, my lord, since the issue squarely covering and directly covering my case, my lord, is pending, my lord, my respectful prayer will be,
That interim order you are talking about,
my lord,
that doesn't lay down any precedential value.
my
If
lord,
there are concluded judgments of this court,
my lord.
this division bench is bound by those.
I'm deeply obliged, my lord, but on
You,
that,
you try to distinguish both the judgments, please. Moklishur Rahman,
Makhlisur Rahman, my lord, in the page 87, my lord, Makhlisur Rahman squarely covering, my lord, there was a straight direction, my lord, to go for fresh meeting, my lord.
Hmm.
My case, my lord, only on a different footing, my lord. Since the resolutions was adopted, not following the mandate of section 15, my lord, when the question of new resolution come, my lord, they have to follow the procedure, my lord, prescribed under 15, my lord. That procedure,
When the writ code, while interfering into the so-called illegality in the motion,
my
directs that no, the motion is not lost. Let the democratic process go ahead. Then why should we take a different?
as per procedure of law, my lord. Section 15 said once motion is lost, my lord, they have to
Come out with any Supreme Court judgment. To the contrary, you might find some Supreme Court judgment that if the motion is interfered, the court can't revive it by an order under 2 to 6.
precisely on that point, my lord, when the matter came up in the writ appeal, my lord, 378, my lord justice was part of that bench, my lord. Precisely the point was, we need further consideration on this point, my lord. And that's
Now you're banking on somebody's shoulder in this matter. You distinguish that these judgments are not applicable to you. And in terms of section 15, once the meeting has been illegally convened, there's no scope for the court to direct for a further meeting to be held within a time-bound frame.
As far as mandate of 15, my lord, no such direction, no mandate of 15, my lord, can come to page of this book, my lord, page 29, my lord.
When judgment would- I'm telling one thing, during that time frame of it, that was also timing that we have to give it in 3 days, 5 days, 7 days. So these are not mandatory that 1 day, 2 days, this way, that way. Not binding. Even judgment.
We'll hear you on 15th March.
Before that, my lord, what I am saying, my lord. What happened, this is a democratic, but the honorable court was used to take the day, my lord, within 15 days to hold the meeting, my lord, as per section 15. But for a moment, my lord,
If at all we are satisfied with your argument, we'll extend that time because time has already been extended. So we'll do it further while deciding the appeal.
So far the argument advanced by my learned counsel, my
Sir, we have given you sufficient indulgence without a caveat.
my lord, we have also filed that contempt petition for not complying with the order of the.
No, but you're not on caveat. You are a party before this court.
Yes, my lord.
Should have filed a caveat.
Kindly please, this is the argument, my lord. Section 15, my lord.
Mukles sort of.
One last part, my lord. Section 15(1) last part, my lord.
Yes.
Last part.
Yes.
Provided for that when a no confidence motion is brought, no such motion shall be allowed in the next 6 months, my lord. Meeting is not lost, my lord.
No court has come to a finding that it was illegally.
There was an
Illegality.
Illegality leads to the meeting being vitiated.
Illegality with regards to holding of meeting, my lord.
Any kind of illegality,
Goes to the root of the matter.
if it was simply a curable irregularity, the court could have allowed you to cure it. It was not so. So illegality, the act doesn't permit any kind of leeway in the matter of fresh, no confidence. Yes.
If it is law, here is a case, meeting is not lost, but 9 members out of 10, 9 members has passed the motion, my lord. Against it, my lord. 9 members out of 10, my lord. Out of 10 members.
Yes.
Pass the resolution, my lord.
It was done without issuing the notice
My lord,
as required by law.
it was issued to him. It was issued to him. What he did, my lord?
SB judgment. These are SB judgments. These are SB judgments you are relying upon, sir. Division bench is seized of the cases of similar matter. No, sir, no. There's no big hurry.
On 9,
Third-
9, on
Yes,
Third Learned Council.
Learned counsels for the parties. This appeal is directed against the judgment and order dated so and so. The learned single judge directed dispose of the writ petition with a further direction that the writ petitioner, as the president of so-and-so Gaon Panchayat, will convene a special meeting within 15 days from the date of the judgment, that is 7/2/2023, considering the motion of no confidence brought against him by the 9 ward members. Where, learned counsel for the appellant submits that this direction of the learned single judge is contrary to the provisions of section 15 of Panchayat Act, and therefore he has preferred this appeal. It is his submission that a similar matter is already pending before the court. And the matter, the division bench is seized of this matter. Therefore, he submits that these matters be listed together. Identical orders be passed in the this appeal as well. Mr. So-and-so appears for the respondent department, and Mr. Chaudhary for respondents 8 to 16. Full stop. Let this matter be listed along with writ appeal number so-and-so 378 of 2022, and in view of the submissions made by the learned counsel for the appellant, let the order of the learned single judge be stayed till the next returnable date. Notice be issued making it returnable on
5th April, or rather, 11th April. 11th April.
11th April. Till the next returnable date, the order of the learned single judge shall remain stayed.
I'm deeply obliged.
In respect of the direction to hold the meeting.
In respect of.
Otherwise, if the entire order is stayed,
Paragraph 21.
see, you are arguing that there should be no stay. And now you are arguing that the entire order should be stayed. The direction contained in the of the learned single judge in respect of holding the meeting within 7 days shall remain stayed till the next meeting.
I'm deeply obliged, man.
Matter number 20.
That once the motion is not even on account of the part, can't be revised by the bishop.
May I please, your lordship? Madam, may kindly because of for time being. My seniors on like another court.
All right.
Obliged.
Matter number 21.
I think the petition filed by the union against the order passed by the tribunal. So we file a miscase. Let's see, I pray that we are not pressing on the miscase matter. Maybe the entire matter may be heard on some other day.
You're not pressing the stay application.
Lots. Entire matter may be heard. Lots.
Listed for admission.
Lots.
It is submitted by the learned counsel appearing for the appellant petitioner, Mr. Ezekiel, that the matter be listed for admission. Mr. Sharma, appearing for the respondent, has no objection. Further submission of the learned counsel for the petitioner that the IA, which is filed for stay, be taken up together along with the writ petition. Attempt. You're not pressing.
Not we are pressing it.
Okay.
Entire matter may be.
It is submitted that the IA is not being pressed. Therefore, the same is dismissed. The writ petition be listed for admission after 2 weeks. An attempt shall be made to dispose of the matter at the admission stage.
Matter number 22.
My file.
What will be the effect of the review? If the review is allowed?
Your lordship, just if review is allowed, then my lord, it again goes back
that for the post of inspector of school, B.Ed BT is not required because an affidavit which has been filed. So Lordship just recollect on last occasion, they have produced before the court this gazette notification, my lord. So Lordship just remember. And what they said that for the post of inspector, they have come up that B.Ed BT is required. But I checked that, my lord, that's why I took time. Kindly look into it, my lord.
You are seeking review of the order at page 136.
Correct. My lord, kindly see this, my lord. In pursuant to the order dated passed by the Honorable High Court in WPC 6907 and pending amendment of the Assam Education Service Rule in addition to other qualifications stipulated under relevant rules of so and candidate for the post of amalgamated cadre, inspector should district elementary and so should have BT B.Ed degree from so and so. So now, my lord. What happened? Yes. So, my lord. It is, my lord, by way, if your lordship kindly see the act. My lord, this act. The act, it's, my lord, kindly see the act, my lord. I think my lordship is holding this. It is.
Act of the rules.
Sorry, rules, my lord, rules. That's page 70. It starts from 698, Assam Education Service Rule 1982. This rule, I'll tell your lordship that rule 8 at 705, if your lordship is holding the same book,
Yes.
705 kindly please look into it, my lord. Academic qualification. The academic qualification of a candidate for direct recruitment shall be prescribed by the appointing authority from time to time. The qualification experience prescribed as on date of commencement of these rules are given in Schedule 2. If you look into Schedule 2, this 713 kindly see, my lord. 713. This is kindly see, this is rule 8 in the top, Schedule 2. Now they, yes, it is 3. Inspectors of school, so and so, master degree having uniformly brilliant career and possessing teaching experience in schools and colleges for 10 years or administrative experience for at least 10 years, of which 5 years must be in teaching. Now, if you kindly turn to next page, 8, Assistant Inspector of Schools, MA, BT or MSc, BT with at least 7 years experience as teacher in secondary schools or at least 5 years experience as teacher in government aided or government college, or MA, BT or MSc, BT with at least 5 years experience as teacher in secondary school and 2 years experience as substitute of schools, or MA, BT or so and so. So, my lord, for the post of Assistant Inspector of School, BABT is required. For Inspector of School, BABT is not required. Even if it is a direct recruitment, I feel myself, this rule is, let me forget about my rule, is not proper. Because it is for a direct recruitment. My lord, promotees is different.
The grievance was that for the lower post, higher education.
Yes. But for this, how they can say that it is not required? But my lord, what has happened? This was not touched by the learned division bench. They said that it has been left to the hands of the appointing authority. There's some judgments. They have prescribed in the schedule. Yes, they have to, my lord, substitute by amendment of the rules.
schedule, yes.
Yes, amendment of the rules, my lord. And what happened? Why we have come for review, my lord? There is an order passed by division bench. The commissioner should file an affidavit to explain what is the position. Commissioner comes before the court, files an affidavit, and they said why for the post of inspector of school BABT is not required, and why for assistant inspector BABT is required. And in pursuance to that, my lord, kindly see the order. The order where we are before this court. At page 136 is the order. At page 136 now. Well, of course, the government can amend the rules. They have to amend the rules by not by way of a
gazette notification, pending amendment of the rules. Amend the rules, my lord, absolutely no problem. But even this is 2016, my lord. Our appointment is 2013. Anyhow, it will be a prospective if any amendment of the rules are being made. That count also, my lord, he has to look into it.
No, but what is your problem now?
Now my problem is 136, my lord. Page 136. That's why I'm before.
No,
this
you are
office.
already in appointment.
My appointment is there,
Ah,
but my appointment has been put to challenge on the basis.
that you do not possess the
Yes.
requisite qualification.
Yes,
Before single bench.
yes, my lord. Now this is, my lord, I appeared and I said this has to be put to challenge. I was engaged in this case. I said this is, and when I argued the matter before the Rane Singh, that I have noted that this is which comes against you. So that's why I thought I will just.
But your appointment is governed by the rules. The rules don't say you require
Right,
BT.
but my lord, kindly see at page 136, which I am before this court. Affidavit, it is not been spelled out also, my lord.
Delivered say. They, in view of the stand taken in the affidavit, so and so. BT is necessary for the post of inspector. That is what the declaration is. So if that is the declaration, naturally, the single bench would say that those who are not having that technique, they are not qualified. Even if the rules are. This is the actual provision. It's not. It's contrary. You. Okay. Then you have recorded wrongly. Expecting you to.
Affidavit doesn't say, my lord, but I think, my lord, it was with great respect to the learned division bench, my lord.
We don't need to demand it, but we simply clarify the order. Yes.
I was the petitioner's advocate in the writ petition, my lord. Our challenge was with regard to this rule, my lord, where we have challenged that
This is a review by the state.
I'm sorry.
No.
private
No,
respondent.
reviewed by
Private respondent.
Private
Yes.
respondent.
You are representing the
Writ petitioners
who are.
who were earlier the candidates for the
Writ petitioners in the judgment, in the case where the judgment has been sought under review.
yes,
20th June 2013.
yes, sir.
Yes.
And the review has been filed after more than 9 years.
So maybe what was your prayer in the writ petition?
There was, my lord, the challenge, the rule was put to challenge.
That was not allowed. Was the rule interfered?
Rule was not interfered, but the court, honorable court has indicated, my lord.
Then the observation is contrary to the rule
And the affidavit?
clearly and even contrary to the affidavit. So there is an error apparent on the face of the record. We have to be, that has to be rectified. But yes, we can request Learned Advocate General to step in and have the rule rectified. Apparent anomaly. Assistant inspector requires PT. Inspector does not require the same. So post of lower category requires a higher qualification.
Pending disclosure of the amendment of the in the second.
No rational. You need to step in, sir.
Yes, Lordship, we'll get it.
This is a simple rectification.
Yes, Lord.
You put it prospectively, you put in the qualification. What is the difficulty?
We'll do it, Lord.
No,
For the time being, we have to clarify this
Yes.
because they are in a difficulty in before the single bench.
Definitely, Lordship will
This
clarify.
observation is contrary to what is contained in the affidavit.
you may just have a look at page 128 of the paper book. Review. There's an affidavit of the state. Para 7.
See, the second part of the paragraph is vague.
The,
Inspecting duties.
that's right.
So that might cover the inspectors also.
Because
That is why this.
therefore the confusion.
The second paragraph of this,
Yes,
subpara of para 7, that causes the problem.
does not appear to be unjustified.
Yes.
No,
So
before that,
the officer having inspecting duties. So inspector is presumed to be having inspecting duties. So in sum and substance, this affidavit indicates that an inspector too must have the same qualification, whereas the schedule does not require.
We'll get it done, Lordship.
We'll review the order, clarify it, that this was not contained specifically in the affidavit. However, the government may take up the issue regarding some anomaly in the rules to be rectified. Okay, we'll pass the orders. Which is-
Once I read also, I felt there no inspector or school priorities.
My lord, apart from the challenge of with regard to rule, my lord, we have put to challenge the selection list also, my lord, where their names appeared.
Before this.
You are not in review, sir.
Yes.
They are in review to clarify
But we had the,
apparent error.
but we had the read petitioners, my lord.
So you should have challenged that order if you are aggrieved.
We have challenged that, my lord, selection of their.
No, this
Single
order,
bench.
No,
Now,
before this honorable court, it was
your writ petition has been disposed of. It's not pending.
in this read petition where they have filed the review, my lord.
Yes.
It was also part of the one of the prayers.
Maybe, sir. But that order you have not carried further. That writ petition is closed.
Yeah.
So what argument have you to make except for us to just make a clarification that this, what is recorded is not a part of the affidavit, as a matter of fact. What else is to be done? Okay.
Briefly, Your Honor.
disposal. Order. Delivery.
Item number 25.
Your lordship, in the last occasion, we were directed to serve the state service upon respondent number 6, 7, and 8, which we have complied. And we've also filed a compliance affidavit.
Lordship, in this case, Lordship, only issue is to be decided whether a hard copy is required to be filed along with the tender or not. That much only, Lordship. Lordship, today I missed the item because my name was not reflecting in the cause. Lordship, I'm praying for listing this matter on Tuesday, Lordship.
I am appearing for the private respondent number 9, to whom the contract has been awarded. Because the single judge, I did not get the opportunity to file affidavit, ma'am. I want to file a short affidavit, ma'am.
Do that in the meantime, while you have served the private respondents 6, 7, and 8.
Yes, lordship.
You are represented. Okay, very well.
Matter may kindly be listed for admission hearing.
Yes.
It is submitted by MS
Q Kiba.
so and so, learned counsel appearing for the appellant, that in terms of the orders of this court, trustee service was affected on respondents number 7 and 8, 6, 7, 8.
7, 8.
And an affidavit to that effect has also been filed. Mr. B. Nayok appears for
For the irrigation part.
State of Assam.
Yeah.
1, 2, 3, 4, 5. Also. And Mr. Chakrabarti for
9.
respondent number 9. Mr. Manan appears for respondent 6, 7, 8. Post of Mr. Chakrabarti submits that a short affidavit, he may be permitted to file a short affidavit. Prayers are allowed. Let the matter be listed again on.
When do you want matter?
On 16, Lordship.
16,
16, very well. 16.
list on 16.
Obliged, Lordship.
Obliged.
Item number 26.
All of this appeal has been preferred against the honorable single judge, my lord. Let my lord will find it pays, my lord, 66, my lord. It starts from page 67 is the operating part, my lord. Here, my lord, a no confidence motion was, my lord, requisition was submitted for a no confidence motion against the president, my lord. Eventually, my lord, the president did not, my lord, approve it. And then it was held in by the Anchalik Panchayat, wherein my lord president, after receipt of the notice, attended the meeting, my lord. And the meeting and the resolution carried against him by 2/3 of majority as required under section 15, my lord. Therefore, he moved before this honorable court, challenging this, my lord, the no confidence motion. Here, my lord, all the members participated. During the read proceeding, 2 or 3 of the members filed an affidavit stating that, my lord, they have put their vote under coercion. So considering all this, my lord, the no confidence motion was interfered with by the honorable single judge. But my lord, as per the settled decision of the apex court, my lord, I have submitted 2018-10 SCC 561. When the president himself attended the meeting after receiving the notice, therefore, thereafter he cannot turn around and say, my lord, the meeting is not in accordance with section 15, my lord. And following that, my lord, our honorable high court will also delivered a judgment, my lord. That is on 22, reported in, my lord, 22/5 GLR 51, honorable single judge, my lord, following that judgment. In a nutshell, this is the case, my lord. Irrespective, my lord, whatever, if there is 22, my lord, 5 GLR 51, Mumtaz Begum versus State of Assam.
This is on the ground, adequate.
But the petitioner, before that, respondent had appealed the meeting.
He had appeared. Must be put to the respondent.
Yes, you had appeared in the meeting. Where is the question of,
We had participated in the meeting.
then,
Lordship, the issue now is the order which was passed by the learned single judge. The equities were balanced, your lordship, because
so,
motion has been passed. There is no question of giving you a second chance. Because, your lordship, 4 of the respondents, people who had participated in the meeting, appeared before the. That is winning over the witness after the deposition. They filed a sworn affidavit before the court. The entire process will be just vitiated if we permit this. No, if I may just take your lordship to the affidavit filed by the respondents. We are not at all bothered. How did they vote in the no confidence motion, lordship? Because what they have said in the affidavit, your lordship, is they were compelled. No, sir, absolutely. They were resigning from their stand taken in the no confidence motion. No, will not permit in the red court at least. Lordship, what they have said in the affidavit, your lordship, is, no, I'll just make one attempt to convince your lordship. What they have said in the affidavit, your lordship, is they were compelled. Compelled in what manner? By political pressure to put their vote. Oh, wonderful. What they have said, what they have only said, your lordship, what they have only said is that we have no objection if a fresh meeting is held.
no,
Why
where's the question of a fresh meeting in terms of the rule?
Why the petition? Then how the sanctity of the process is to be maintained, sir? Because if people are allowed to change their color like lizards now by coming into the courts. Now the president, your lordship, as long as the members are saying that we still have confidence in the president, your lordship. He'll be re-elected. No, because there is no scope for re-election, your lordship. Now the why not? Under Assam, they will have to elect another president. The president, your lordship, unlike in some other states, is not a member of the Panchayat, your lordship. He is directly elected. And the others are once he's removed, your lordship, unless a fresh election is held. Wait for the turn when the fresh election is held. So, your lordship, but in any event, I'll only attempt no confidence motion has been gone through. This court will be loath to interfere therein. No, lordship, only the only cause why the learned single judge passed this order was because it was in the nature of a consent order. No, the people who participated in the meeting, they came and said that we have counsel, we can't rely upon affidavits. Assuming that we adopt this process, lordship, in criminal appeals, lordship, the witness comes in and files an affidavit. No, I gave the statement in coercion. Lordship, in a criminal, it will create chaos. In a criminal, there has to be a finality to a process, and this being a democratic process, it has all the more favors sanctity.
Lordship, in a criminal process, perhaps the standard of proof, the standard will be different. But here, your Lordship, when the people are saying that
Yes,
we were compelled,
That's true.
we were compelled, a fresh meeting, your Lordship, would not.
Compulsion in what manner?
What they have stated in the affidavit, because I'm not holding their briefs, only
Read.
what they have stated in their affidavit is at paragraph number 6 at page number 51,
That the president has been able to win us over back.
that it is admitted that being influenced by local political leaders, we were compelled to
Who?
put us.
Have they named anyone?
They've
How
not
do
named-
we accept this affidavit? Which local political leader? When they come out with an affidavit which is to be accepted as evidence without being controverted,
Lordship.
it has to be absolutely convincing. Which political leader? What was the date? What was the manner of coercion? What they put under gunpoint?
Your Lordship, once it is under, it is not free, your Lordship, even.
Absolutely no, sir. This is unheard of.
Lordship, because only a meeting has to be held, your Lordship. Let the meeting be
Very,
held.
very simply put, Mr. Counsel. Thank you.
Lordship, let the meeting at least be held. That is my only submission, Lordship.
Not required, sir.
The provision, you have to prove that there was an illegality.
But at least they've said so on affidavit, your Lordship. This needs to be taken.
That's a vague affidavit.
But once it has been placed before.
And
your
they have
Lordship-
given, it is not their case that they were forced to appear. They were unaware that
You are asking us to review the
voting
proceedings of
was.
confidence motion in 2 to 6.
They are asking, your Lordship. The person who
Anyone-
participated, they
anyone
are asking,
For that matter,
Lordship.
anyone for that matter, is review permissible?
No, Lordship, once
Once it is held that the no confidence motion proceedings were as per law, there is no question of allowing. And the participation was there. So no notice finding can't be given.
But what the learned single judge went on the premises, since these persons are saying that we want a
That
fresh
would
meeting.
not have been the reason. Either the confidence motion, no confidence motion should have been caught on ground of non-compliance.
Mhm.
Or else, whatever the result is, the will of the participants, that has to be respected.
Then Lordship, may I just make one prayer? Let the writ petition be remanded back to the learned single judge, because this was a
No,
ground
no,
which
no,
was not
sir.
agitated by the petitioners for the learned single judge. We'll try and convince the learned single judge.
Okay, sir, we have heard you.
Very well. Obliging.
Now, all the parties are represented.
All the parties are represented, your Lordship.
Okay, heard. Disposed.
Obliging.
Matter number 27.
हाँ, मैं लिखा हूँ। भेज दीजिए।
Please, also, in this case, my lord, on 80, by order dated 18/1/2023, my lord. The directed to serve notice of the respondent number 6 by registered post as well as to take step for Dosti, my lord. That we have taken, we also file affidavit today regarding the taking. Subject notice of the respondent by Dosti, my lord. I have filed this affidavit today, my lord.
You are appearing for
I am appearing for respond about 7 and 8.
7 and 8.
7 and 8.
And who are the other respondents?
And I responded to 1 to 5 state and 6 is the, my lord,
No, you have taken Dusty on whom?
on 6,
6.
on 6, my lord. Today we have filed affidavit regarding taking
6, okay. Mr. FKR Ahmed, the counsel for the appellant, submits that in terms of the order dated 18/1/2023, steps by Dusty has been taken on respondent number 6,
6, my lord.
and an affidavit to that effect has been filed
Today, my lord.
today. Also, Mr. Kumar appears for respondents 1 to 5. And Mr.
Yes, Islam.
S. Islam appears for respondents 7 and 8.
Yes.
Let the matter be listed for admissions after a week.
My lord.
Registry is directed to make the necessary reports in respect of service taken by Dusty
Yes,
on
my lord.
respondents number 6 and 7,
And this.
and matter be listed thereafter.
My lord. All right.
Matter number 28.
Lordship, I'm praying a time, Lordship, to file an additional affidavit. Lordship, yesterday it was intimated, Lordship.
Item
28 or 28. Adjournment slip is there.
Also, I'm praying
Any
for-
objection?
Objection? It will only, that my lord, we are not, we are, I'm the contractor, my lord. Works were executed duly, my lord, we are not getting payment, my lord.
He is praying for an adjournment. Do you agree or you disagree?
Agree to that, my lord. Lordship, it
All
will
right,
be, my lord.
at the request of Mr. DJ Das, learned counsel for the petitioner, for the appellant,
Appellant,
uh, matter is adjourned for
Lordship, 3 weeks, Lordship.
3 weeks.
Lordship, actually, the holy vacation is there in the meantime, Lordship.
Prays for, and is granted 2 weeks' time
2 weeks.
to file an
17 March.
additional affidavit. Learned counsels for the respondents appearing do not object to the prayer made.
17 months.
Based on 17
Based on 17 March.
Matter number 29.
Lordship, on the last. Lordship,
Yes.
on the last date, we were instructed to file our IA. However, we are not certain about the person who is currently in charge and replaced respondent number 1. So Lordship will, with your permission, we'll need a day or two to know the name of the person who's currently in charge and file our IA, if that's okay.
Lordship, that means.
Respect of-
File an implement petition. Lordship.
For
Yes.
impleading
Respondent, the person who was replaced respondent number 1.
1.
Yeah,
Okay,
Lordship, one has taken over
Will-
charge of another post, Lordship.
all right.
we'll take the name from the learned counsel.
MS so-and-so learned counsel for the petitioner submits a further 2 weeks' time be granted for filing the necessary implement petition for impleading the present incumbent to the office of respondent number 1.
Lordship.
Mr. M. Bhagavati, learned counsel, appears for
Respondent number 1. Lordship.
the
Present.
respondent number 1.
The new implement will be 3. Lordship.
Let the counsel for the petitioner file the implement petition as prayed for, list after 2 weeks.
Matter number 31.
Who is now already. It simplifies because of that. Reduces one more. The amended cost, that's. Yeah, amended cost certified with the name of the author currently already. And the government that was considered. Represent. Is no private representation. of the- The government. If they want to engage. We can.
May I please, Lordship? In this case, we serve the notice on the respondent through Dusty, Lordship, and file affidavit to that effect, Lordship. But nobody appeared.
Let the registry report. Is there a report?
We file affidavit on 25th of November. Lordship.
Has been filed, yes. Like a.
For Dusty, Lordship.
Dusty.
What?
It is submitted by Mr. SCKL and counsel appearing for the petitioner that in terms of the leave granted by this court, a Dusty affidavit has been, service has been effected on respondent number,
Only one respondent. On 16.
sole respondent. And a Dusty affidavit to that effect has been filed. Full stop. Registry is directed to
Yeah, already report is there.
Service may be
Service was effected on 16th November. As a matter of fact,
Lordship.
10th January का report. 10th January. Yes, affidavit is there. Subsequent report. Okay. Okay. So this is the reports. This affidavit was filed on 25th November. So. Team. Services complete that report is to the yes. Report is there.
The registry is directed to complete a report on the services affected, on the completion of the services affected, and list it thereafter accordingly. List after 2 weeks.
This is name of
Just after qualification.
He's appearing on behalf of earlier Mr. Gupta was appearing.
Yes, sir.
Now there's a change of counsel.
Yes, sir.
Was his name is shown.
My name is shown in the
Yes,
respondent
shown
side.
on this side.
Your name is shown on the other side.
Much okay.
Matter number 32.
Make major order. My lord, application for condonation of delay was dismissed on 25th of January 2023, my lord, for default, my lord. And this is an application praying for my lord, restoration. Today, that is the only prayer. My lord. My lord,
State representations.
yes, yes.
Who's appearing for the state?
I'm appealing for this.
There is a restoration of this to Mr. Lear.
Who's,
Yes.
we will have to issue notice.
My lord,
There's a-
in the condonation application, no notice was issued. My lord, condonation application was
Delay
dismissed.
combination was dismissed for non-prosecution. We restored the delay
So
combination and
for
then
restoration, I think no notice is required.
you restore the application and then issue notice. One step is reduced. But that application is not there.
Yeh to application.
This application is for restoration of the delay convention. That is also there. We'll issue. Was dismissed, so it will be restored and the notice thereof is to be issued.
Yes. Notice.
And issue notice of the IA number 158. My name may be.
I-13 of 2023 is filed by the applicant, Department of Chief Engineer Water Resources, seeking restoration of the delay condonation application being IA number 158 of 2022 in writ appeal serial number 15460 of 2022. Full stop. The learned counsel for the applicant submits that the IA was dismissed for non-prosecution. Therefore, by the order dated
25th January.
25th January 2023, he submits that the same was dismissed as he could not appear before the court due to inadvertence on his part. It is submitted by the learned counsel that the item somehow escaped his notice and which was not at all deliberate, nor on his account of negligence, but for reasons beyond his control. Para. Having perused the grounds urged, we find that the dismissal order can be recalled. Accordingly, the IA is allowed. Order dated 25/01/2023 is recalled. The IA 158 is restored to file.
What is issue for the default?
In 158, heard so-and-so, learned counsel appearing for the applicant. This is an application for. But who's filing? Who's the petitioner or the applicant? Chief engineer.
My lord.
Should it not be the state?
My lord, in this case, yes, he is authorized, my lord, in this regard. Because
Why don't
he
you
will
have
be.
the state through the chief engineer,
Especially-
not happily worded.
My,
Maybe in the writ court, he was made the respondent. That might be the reason.
Yeah, but then also it has to be the secretary.
First title is not.
The secretary is the party.
He must have been a party in the reputation.
Where is the order?
168.
Order of my lord.
Single bench.
Single bench order, I think,
Yes.
state was a party through the secretary.
Yes,
So you're in appeal against this order.
yes. And today, my lord, as additional advocate general, I am appearing, my lord.
That's right, but the appellant has to be the state.
My lord. Of late.
So you'll make the necessary amendments, we permit you to do that. You make the changes in the course title.
Right.
Unless there is a specific order that you want to rely on saying that the chief engineer is authorized to prefer an appeal against the state on behalf of the state.
Right.
Issue notice, returnable 4 weeks. Steps on respondent by registered post within 1 week from today. Dusty is also permitted. List accordingly. Learned additional AG is also permitted to make necessary corrections in the course title in the presence of the court master.
My lord, this time, my lord, my name can be directed to his own, my lord.
The names of all the councils be reflected in the course list.
My, yes. Also, it will change to it.
Mr. Additional AG, because it causes some problem with uploading, what you can do is you file a corrected course title, amended, and file it in the registry. Make the changes, file it in the registry, they will connect it to the file instead of hand.
You do that.
Because I think no signature.
No, yes, amended cost title can be filed under your signature. Do it today itself.
Matter number 33.
Against the order of the National Complaint or Tribunal, my lord, without filing any appeal, my lord, they directly came to the High Court under review. My lord, here, my lord, the section 12 of the IB Act, my lord, that has been amended twice, my lord. I'm just placing the, my lord, amendments. If you will see, my lord, the original is, my lord, in the they want, my lord, that the insolvency process should be completed. The company should not go on liquidity. First, my lord, the second page, my lord, your losses may see the how originally it was there.
Prior to amendment.
Prior to amendment, yes. Originally. Second. Subject to subsection 2, the corporate insolvency resolution process shall be completed in a period of 180 days from the date of admission of the application to initiate the process. Resolution professional shall file an application to the executing authority to extend the period of corporate insolvency resolution process beyond 180 days if instructed do so. By resolution passed at the meeting of the committee of the creditors by a vote of 75% of the voting shares. On receipt of an application or subsequent to, the executing authority is satisfied that the subject matter of the case is such that the corporate insolvency resolution process cannot be completed in 180 days. It may order extend the duration of such process beyond 180 days by such period as things fit, but not exceeding 90 days. So total was, my lord, 270 days earlier. Provided that any extension period in corporate insolvency process under section shall not be granted more than one. So that thereafter, my lord, in first page, my lord, the second part, your losses may see. That there is slight amendment, my lord, this is 75%, it was made 60% of the creditors. Except 66%. So your losses may escape the second one, the first one your losses may see, my lord, which is after the amendment. This, my lord, the first sections, subsections 3 are there. Then proviso has been added, my lord. Your losses may just come to that. 2, provided. Provided further that, my lord. The corporate insolvency resolution process shall mandatorily be completed within a period of 330 days from the insolvency commencement date, including any extension of the period of the corporate insolvency resolution process granted under this section, and the time taken in the legal proceedings in relation to such resolution process of the corporate debtor.
provided also that where the insolvency resolution process of a corporate debtor is pending and has not been completed within a period referred to in the second proviso, such resolution process shall be completed in a period of 90 days from the date of commencement of the Insolvency and Bankruptcy Amendment Act 2019. So, my lord, here 330 days is made, my lord, absolutely, and even, my lord, pending matters 90 days more.
90 days more. Yes.
So they are granting more time, my lord, so that insolvency process is completed. The company should not go in liquidation, my lord. Now, in the Eastern case, what happened, my lord? The second time, my lord, the National Company Law Tribunal has granted extension. My lord, originally 180 days, then 90 days, then, my lord, again 30 days. Page number 85. Page number 85 is the first extension, my lord. If you also see.
So this is a process post amendment.
Post amendment.
Right.
Post amendment. So it is 330 days minimum, my lord. So 270 days granted, then again 30 days in this section. 135 is that, my lord, improving order which was into here. 135, my lord. You lost it. This was not an application under section 12 also, my lord. They filed an application under section 65. This is hearing. This application under section 60, subsection 5 of the Insolvency Bankruptcy Act, Rule 11 of the National Company Law Tribunal rules. This is inherent power, my lord, of the Company Law Tribunal. Filed on behalf of the resolution professional seeking extension of the corporate insolvency resolution process beyond 30 days. In this matter, CRP was initiated on 23/11/21. 270 days are going to expire on 28/22. Third, Mr. P. Gagar, RP, in person along with Nirmal Goenka and Luxis Chokhani, it has been submitted that a resolution with regard to the extension of the CIRP was approved with 82.7.26 voting by the members of the company. The prior and the present application allowed whereby extension period of CRP for a period of 30 days beyond 270 days. So, Lord, 300 days is granted, my lord.
Whereas the provision says that it is 330 days.
330 days.
And then extension.
Yes, 90 days.
further 90 days.
My lord, here what happened, my lord? Because they are relying on the, my lord, first proviso that extension cannot be granted more than once. My lord, that was virtually prior to amendment. And moreover,
How is the learned single judge dealt with this aspect?
yes, my lord.
This very order was challenged.
This order was challenged without going to the, my lord, National Company Law Tribunal, Central, my lord, because there is an alternative remedy under section 60, one of the appeal, my lord, act, and stating that there is no alternative remedy, my lord. My lord, virtually the SR still judgment was relied on by the single judge, and that has clinched the whole issue. If your losses comes to page 240, my lord, the SR is still in the paragraph 127. That is the main trust of matter, my lord. I am giving the entire judgment also, my lord. At 127, the paragraph that has dealt with the matter, my lord. Page 240 of the appeal, my lord. The losses, my own, what the para only will be. Both the judgments of Atma Mittal and Sarah Matthew have been followed in Niraj Kumar Saini, so and so, SCC para 2932, given the fact that time taken in
So the resolution professional was not aware of the amendment or what? Why did he move the application?
amendment was known, my lord, to them.
Then why did he move the application? That 330 days was not over by then.
That is correct,
He
my
is
lord,
mentioning
but
270 days.
already NCLT granted 180 days initially, then 90 days. So we have to take a permission, my lord.
No, we are asking you.
Yes.
The statute says that the time limit is 330
330
days.
days.
So the NCLT granted only 180 days.
180
earlier.
Yes.
Okay.
Then 90 days. It comes to 270. Yes, ma'am. So, my lord, 240, my lord, of the memo, my lord, there 127 para has been quoted of the SR steel judgment.
127.
120. That is the. Chalo.
Yes.
Yes. Both the judgments in Atma Mittal and Sarah Mattu have been followed in Neeraj Kumar Saini versus State of UP. Neeraj Kumar Saini versus State of UP 14 SCC 136 SC para 29. Given the fact that time taken in litigant's case within requisite period for no fault of the litigant, a provision which mandatorily requires the CIRP to end a certain debt without any exception thereto may be an excessive interference with the litigant's fundamental right to non-arbitrary treatment under Article 14, an excessive arbitrary and therefore unreasonable restriction on the litigant's fundamental right to carry on business under Article 19(1)(g) of the Constitution of India. This being the case, we ordinarily had struck down the provision in its entirety. However, that would then throw baby out of the bathwater. In as much as time taken in a legal proceeding is certainly an important factor which causes delay and which was made previous statutory experiments fail, as we have seen from the Madrasa Petrochem, so and so. Thus, while leaving the provision otherwise intact, we struck down the word mandatorily as being manifestly arbitrary under Article 14 of the Constitution of India, as being an excessive and unreasonable restriction on the litigant's right to carry on business under Article 19(1)(g) of the Constitution. The effect of this declaration is that ordinary time taken in the relation to corporate resolution process of the corporate sector must be completed within the outer limit of 300.
Where is the order of the NCLT whereby only 180 days was granted and then 90 days extension was granted?
Yes.
What was the reason for not at the first instance granting that 330 days period? Any rationale behind that?
The initial time, my lord, was given the section as 180 days. That is why, my lord, it was given, my lord.
That is what the first question we put to you.
Yes.
Were the proceedings initiated before the amendment or after the amendment?
After the amendment.
So then at that time, the period was, okay, in subclause 3, it is 180 days. In the proviso, it has been given.
Proviso has been added.
Yes,
That is why.
correct.
That is why, my lord.
So then the proviso, first proviso says extension can't be more than once.
Once, but that was prior to amendment. While amending, my lord, that has been not been deleted, that remained. So NCLT.
No, this is in the amended section.
Amended section is remained, my lord, original section. That proviso. That was proviso is in the original section.
Okay.
But during amendment, it should have been deleted, but it was not deleted. But NCLT is the power under section 60 also, my lord, as well as rule 11 of the NCLT.
This amendment of 2019.
Yes.
It says that 180 days and 90 days.
90 days.
Where is this scope for further extension?
My lord, the proviso is that was, my lord, the case, my lord, because insolvency process litigation takes more time.
There is some confusion, sir.
Yes.
The amended, lastly amended provision is on top of the page.
Yes, top of it. The second proviso. Second proviso is the main one. That was added. Second proviso, third proviso, two proviso added.
Yes, given it 3 places. Current one is this. This proviso is there even in the amendment.
Yes, but that remained as it is, my lord. But they have added another proviso. So company law tribunal has the power to grant extension up to 330 days.
330
minimum.
And
more 90 days more, my lord, after 330 days also.
Yes. No, second proviso is for pending proceedings.
Yes.
So pending on the date of the amendment.
Correct.
So that is not the case here.
No.
So you are banking only on the
Second proviso.
second
Not third
proviso.
proviso. Second proviso, my lord. But in SR still, my lord, has gone further that beyond 330 days also it can be granted.
Mandatorily has been struck down.
Yes, yes, that has been struck down and it says that it can be granted. Because everybody wants, my lord, that insolvency process should be completed. The company should not go on liquidation.
That order of extension has been successful. Let's hear the other sides.
This amendment was, my lord, considered in the SR skill case, my lord, that was. And in para, my lord, if a lordship takes up, my lord, they.
You are against an interim order of the single bench.
No, final order. my lord.
Final order,
Final order.
22nd December.
Yes. My lord, if your lordship takes up the SR skill case, my lord. The 127
Learned single judges interfered with the extension order.
extension. Extension. Only on the basis of the past proviso, my lord, mainly. But NCLT has got enough power, my lord, under section 60, subsection 5, as well as rule 11. Inherent power is also there, my lord.
Yes, Dr. Sir.
Section 12 of the act. Now you're also missing first proviso and second proviso. Now the legislature, while amending the section, has consciously not deleted the first proviso.
Seems to be an aberration, sir, on the face of the record.
My lord.
Otherwise, this 330 days would become redundant.
Well,
Actually,
I've submitted. For the 330 days, you're also seen the purpose of 330 days, if you're also some legal proceedings. were there.
dependency of legal proceedings.
There was no legal proceedings pending. There was no proceedings pending. Otherwise, my lord, you're also fine. The first proviso will become redundant. There will be no use of it. The first proviso and the second proviso, existence of both can be only, my lord, given effect to when, my lord, one operation is a different field and two operations in different field. If, my lord, certain proceedings were stayed, and because of that, my lord, the 180 days and the further period of 90 days, the proceeding could not be completed, then 330 days. Now, the Supreme Court
You
said,
have to look at it in the context that the word mandatorily has been struck down by Honorable Supreme Court
well, that
in
has
SR
been-
Steel.
that has struck down for a reason, you know, that if the effect of the granting the extension is to put the corporate debtor back to its feet.
So we can't prejudge that. Maybe the extension would work out that way.
So that, it was argued before non-single judge, you know, and non-single judge inquired from them whether the process is for putting the corporate debtor in his feet. And specifically, it was said that no, they are handing over to somebody else. Corporate debtor is somebody else, below, and putting them behind the back doesn't mean that the same thing will be handed over to else. Well, that doesn't mean because corporate debtor is the person who was the.
Ultimately, it is the industry which will be surviving. That is the purpose.
My lord, your lordship just I have gone through your lordship judgment in the morning when we were sitting in the division bench in the Rajasthan High Court. My lordship given a judgment on the insolvency law.
Yes.
In fact, I could not go through this. Also have been discussed. In fact, I could not go through the judgment in the
No,
morning.
there is nothing special. We have just followed SR Steel. Nothing
No,
special.
because
about it.
there is something in the judgment, there is one judgment, and your lordship dealt with the various aspects of the insolvency law and the purpose and all
Yes,
these things
please. Yes,
have
please.
been dealt with. Although that will be persuasive value for your lordship when sitting in the Guwahati High Court, my lord. But
Yes,
my
please.
submission for lordship that, my lord, that it cannot be said that the first proviso is by implication.
For that purpose, then we'll have to consider the appeal on merits.
My lord. Yes,
For that purpose, we'll have to take up the appeal on merits.
there is. Your lordship has to take up hear them, my lord, the
Yes,
appeal on merits.
and if we do that, then we'll stay the single bench order, which in effect
No, it
would
is-
have a.
No, status quo is already there. There is a status quo order already passed by this court.
Not status quo. We'll stay the effect in operation.
My lord, if
That
your
would revive the extension.
my lord, if your lordship passes that order, my lord, your lordship has seen. If my lord, thereafter, if subsequently, if your lordship decides in my favor, as is happening in the Supreme Court, my lord, now,
We'll just try to wait for that period of 30 days. If the process is completed in the meantime.
my lord, 30 days is already over, 330 days is already over. Now the question is that, my lord, if your lordship, just my, if your lordship passes the order.
So that 30 days period is also over as per you.
Over.
What happened in that period, sir?
Nothing was done.
No, after the period was over, my lord, we filed an application, my lord, because 87 point, my lord, we have given that, my lord.
No, question here is, sir, that You've been given sufficient time. It is 330 days. When was the process started? Can we know the date of initiation?
Yes, ma'am. High Court has stayed the proceeding before the NCL. One second, I can take it.
High Court stayed only the extensive part, nothing else.
So by the time the stay was passed, how much time had elapsed?
You will see, Milord.
Second extension. Second extension, the page. Second
What is the date of initiation? Can we know, sir?
date of initiation.
Yes.
Melody, that is in the 135, page 135, it is there, Melody.
135.
Yes.
Yes.
This Melody resolution.
23rd November 21.
Yes, that is the interim order, what Mr. Para 3. In this matter, CRP was initiated on 23/11/21.
Yes. So
And
period of 330 days plus 30 days. That
270
ended
days.
in November 22.
Yes. Yeah, October. Yeah.
Rather in the 22, January 23. That 330 plus 30.
No, 270 plus Milord, in this case.
Because
270 plus 30.
270 plus 30.
23rd November 21.
My lord.
1 year, 365 days
Milord,
on 23rd November.
It was 180 days, then 90 days of extension.
We are talking about the
My
total
lord,
period which has
My
lapsed.
lord, my lord. Absolutely correct.
So was there a stay of proceedings before single bench?
No,
Yes.
no, there was only stay of the extension. This was given that.
That is automatically, my lord.
No, that cannot automatically. How it can be automatically? If the second extension cannot be granted, then there was no stay at all.
Process is stayed.
You will show me the process was stayed in the interim order.
142. 142, my lord. 142 it is there. That is the order. My lord, at page 144, the last para, my lord, your losses may see this
And your lordship,
single bench
just
order.
observe, my lord.
Single bench
that,
interim order.
For this, only just, my lord, if the assuming that the order of the single is stayed and the process is completed, everything handed over. My lord, your lordship, the apex court is now facing the problem in the constitutional bench because of the interim order, the extradition part again, because the same problem arising, because something will not come back. The main thing is being argued is only restitution because of the interim order passed by the court. That something happened and thereafter it cannot be restituted. Well, my submission before your lordship that not that only single judge.
All right, we'll hear the matter sir, finally.
That will be because let
My lord,
the
my lord,
judgment of your lordship.
Many consequences,
My lord, in the
many-
admission stage, my lord, it may be
many
hard.
possible outcomes, yes.
It may be admission stage, my lord.
Admission stage or hearing stage, I have no objection to that. my lord,
It
because-
doesn't make any difference.
My lord. Because the matter requires my lord, early disposal, my lord.
Well, why the resolution professional is so much, but you know, the corporate debtor, the COC, they should be worried. The resolution professional should be independent. As you lordship has seen, the judgment of the Lord,
This appeal is by the resolution.
Yes.
professional.
resolution professional, how he can be,
But, my lord,
that shows that he is not independent at all.
Anxiety is not very acceptable of the resolution.
Well, it seems that he is not the independent one then, he is coming up in the
my
appeal,
lord,
that itself is shows the bona fide,
Partisan stand apparently,
my lord.
yes.
that's it.
So, all right, we'll hear it finally in May, maintaining the status quo. We'll hear it finally at this stage.
My lord, this. Then it be my lord, the 3rd week of March, my lord. 3rd week of March.
Not possible, sir. Just not possible.
By who can be, my lord, we are the operational creditors, by any means, my lord, they want to, the resolution professional interested, that is most interesting part. And he said, my lord, in the meeting, the second extension cannot be granted. And the COC said, no, you file the application, and he has filed it. That means he's acting on the behalf of the resolution, the committee of creditors, my lord, he's not independent one.
The facts are not neither here nor there.
I is there, if you want, I can show everything,
Sir,
everything is there.
no arguments amongst yourselves. Sir. You are both seasoned counsel.
Yes.
The matter requires detailed consideration. Thus, list for now after hearing arguments advanced by counsel Shri Saiwala, Senior Counsel Shri Saiwala, and Senior Counsel Dr. Saraf. we are of the opinion that the matter requires extensive hearing. List for final disposal at administrative stage on 8th May.
In the meantime, I will go through your lordship judgment also because I was finding that very interesting.
That judgment has no bearing on this controversy.
No, no, the lordship has seen the.
I am aware of that.
Well, the status quo order may continue, my lord.
The interim, the order of status quo pass on so and so shall continue.
My lord, I'm grateful to your lordship.
Basically, it was.
Item number 34.
Recovery notice after the finalization.
Item 34, my lord. I am appearing for the respondent.
Judgment of the High Court. Demand notices of the legislative department. Is satisfied. Demands prior to paper for finalization of CII.
My lord,
Yes.
item 34, I am appearing for the sole respondent, my lord.
Yes.
I need to file my objection, my lord. Notice was issued on 30th of January. So 2 weeks time may be granted, my lord, to file my objection.
Mr. J. Roy, Learned Senior Counsel, appearing for the respondent, prays for, and is granted 2 weeks time to file objections
My lord,
to the application for limit. What is the
Condonation.
delay?
condonation.
Only 32 days, lord.
Huh?
A delay of 32 days in filing there.
Let me file it, my lord.
Let him file. the
All right,
objection. We'll consider. it.
Mr. S. Setia appears for
Still
the,
condone, there is no problem.
S. Setia appears for the applicant. List after 2 weeks.
My deep down.
There are some things to the advantage of
Lord.
engaged senior counsels.
Item number 35.
May I please, your lordship? This interlocutory application has been filed for condonation of a delay for 27 days.
Do they have any objection?
Who's for the respondents?
My lord, I am appearing.
Only one.
Yes, madam.
How many respondents?
All respondents.
State,
Yes, madam.
any objections?
No objection, that should not be recorded.
State can be benevolent enough.
You're not
Not
filing any
objecting.
objections. Written objections, you're not filing.
No.
Yeah, I heard Learned Counsels, his application is for seeking condonation of delay of 27 days
27 days.
that had occurred in filing the connecting writ appeal against the judgment and order dated so and so, passed in WPC number so and so. The grounds have been perused. We find the delay has been sufficiently explained. Further, no objection. The respondent counsel has does not offer any specific objections to the delay caused. Accordingly, the IE is allowed, delay is condoned, registry is directed to register the writ appeal and list it before the court.
Return. Return is senior counsels. I want.
Item number 41 of supplementary list for orders.
May I please, your lordship? No, the pleadings is completed, my lord. And this matter relates to my lord, tender process by which my lord, the respondent number 8 has supplied some articles to the official department, Assam State Corporation, by submitting for manufactured document. And this document has been admitted by the respondent itself. The documents are forged one. And subsequently, the respondent number 8 has also my lord, admitted that the said documents are not genuine and they have not submitted the said documents. And to rely, in relying the documents which have been submitted by the respondent number 8, they have submitted documents, furnished documents along with their affidavit. And in that regard, the petitioner has filed an application on the RT Act before the authority who has issued the said certificate. But that was also my lord, found my lord, not genuine. I am my lord, submitting all these facts. That regarding my lord, BGRS scheme, my lord, the Assam State Corporation has my lord, photoed e-tender.
for supplying peas, my lord. The respondent number 8 has participated in the said tender process. And by in view of the supply order, he's might have supplied the peas, my lord. When my lord
Seeds.
Seeds.
seeds, my lord. When
So
he has
what are your prayers for causing an inquiry?
causing an inquiry as regards to my lord, taking money.
What is the stand of the department?
Stand of the department is such that the department has admitted that documents which the respondent number 8 has relied on the strength of which the amount has been received by him are not genuine. That is not also the affidavit of the respondent number 8 as well as he himself has stated.
Lordship, I'm appearing for the respondent number 1. Here, Lordship, the NIT was issued by the Assam Seed Corporation, a complete separate entity. And we have found out that the certificate relied upon by the private respondent was forged. And by that time, he has already completed the contract and taken away the money. On finding out that the certificate was false, we lost an FIR with the police. Lordship, now the investigation is going on, Lordship.
And what about any step of blacklisting or something of sort?
Lordship, that Assam Sikh Corporation Council is there, he can submit, Lordship.
No action was taken.
That process has to be initiated by them.
I'm repeating Assam Seed Corporation.
Yes, please.
My lord, so far this party is concerned, we have not allowed him any to participate further any kind of
Is there any formal order whereby he can be blacklisted?
blacklisted. Yeah. Okay, I get the instruction.
And what have you done? Have you made your in-house inquiry? Because in the scrutiny of documents, your officials also must be involved. What have you done about them?
My lord, the investigation, my lord, a case has already been registered and
There is a criminal case that will take its own turn.
My-
Consequences will follow.
My-
But what have you done about the incorrect
Internal.
scrutiny of the
in-house.
documents?
Yes, my
Which are
lord.
forged admittedly.
My-
What is the forged document precisely? Can you tell us?
My lord, the germination test report certificate.
Test reports.
My lord. That is required to be submitted along with the melody.
So those certificates are forged.
Force, my lord.
And these certificates are issued by which authority?
But Assam State Seed Certification Agency. That is another agency, my lord. That was my lord, in view of the honorable court's order, my lord. Authority has been implemented and notice was issued, but not appeared. My lord.
Not appear. But then what is the basis of your saying that the reports are forged?
My lord.
It's an admission by respondent number 8.
No, my lord.
Then-
Prior to that, I have filed application on the RTI, my lord. In response to my application, the ASCA authority has intimated that those documents were not issued in the name of my lord.
Can we have the latest status report on the criminal case, please? You keep your IO present in the court with the case, Zari. We'll find out. No, we'll ask the IO what he has done. If this is a case of fabrication of public documents, report of the state laboratory, that's a very serious matter. If persons are allowed to procure contracts on this basis, then that is really unacceptable. So all right, you keep the report available.
Already investigation is going on.
Heard learned counsels for the parties. MSRB Bora. Learned State Council submits that is directed to produce the report, status report pursuant to the investigations
Into FIR number,
initiated by the FIR number
CIDPS case number 17 of 19.
CID case number 17 of 2019.
almost 4 years now.
Full stop. Let the report be presented before this court by the next date. List again on so and so date. 2 weeks, we'll give you 2 weeks.
22nd March.
22nd March, listed on 22nd.
Matter number 38 of daily list for hearing.
The shampoo meeting report. Sir, can we have it after April? Because till April, we are deeply into the platinum jubilee.
As per lots of convince,
Just after that. It's not. 20th April would find
Would it be on 2nd of May, Lordship?
2nd May.
2nd. Deeply obliged.
I'm obliged.
Item number 40.
My lord, may the matter may be taken up after some time. The engaged council minister R third is appearing in another court.
You want us to take it up in second round?
No.
Today you want the matter to be taken up? Very well. Pass it over for the day, for the time being.
Second half, my lord.
Yes.
Item number 42 to 44 of supplementary list.
I think, my lord, we'll have to seek some clarification from the Supreme Court. I've examined the matter, my lord. Only thing is, my lord, the Honorable Single Judge referred to Honorable Supreme Court judgment, my lord, regarding the delay aspect. The third para, my lord, sub para 22.2, which goes in our favor, my lord, that was not quoted in the order. Because the Supreme Court also says, if the judgment is in rem, then here what had happened, my lord, the same appointment was challenged by a set of petitioners. Their petition was allowed. Same selection, my lord. In fact, there was an inquiry by the department. In the inquiry, it was found that they are not to be blamed. It's not that the candidates were guilty of any wrongdoing, but my lord, there are some procedural lapses.
Right.
Based on that, my lord, the learned singular of this honorable court allowed the writ petition, permitted them to join similarly placed candidate arising out of the same selection. That appointment was, of course, there was a delay, my lord. Then that writ petition, writ appeal was dismissed. SLP filed, SLP also dismissed. But thereafter, my lord, this petition is filed. The Supreme Court has, of course, said, my lord, that even if the judgment is rem, then the court will also get satisfied whether they are guilty of delay or lapses or acquiescence. That observation is there. So I think, my lord, since now seems exactly similar matter.
Same order.
Same order.
Same date order.
Therefore, I think we'll have to get a clarification from the Supreme Court.
Current counsel, Sri Chaudhary, frankly concedes that controversy involved in this writ appeal is covered by the order dated 27/2/2019, thereby, appeals against the very same impugned order dated 1/2/2018, passed by the net single bench in writ petition number so and so, connected writ petition number so and so, was dismissed. In view of the submission noted above, without recording separate reasons, the instant appeal is also dismissed in view of the judgment rendered by division bench in case.
There are three cases, Father.
Yes, all three.
My name may be recorded.
Yes, attendance will be there.
Lordship, I'm sorry.
Call them. As a matter of fact, once the attendance is recorded at top of the order, we need not mention that so and so appears, because the appearance is already there.
Lordship.
That is just a repetition.
Item number 15, passed over matter.
Here, later on.
May I,
Certain.
may I please, as your lordships, my lord?
Yes.
My lord, the matter relates to, my lord, an examination which has been conducted by the state of Assam, my lord. Is a TET examination for the purpose of, my lord, recruitment of teachers in the various provincialized madrasa institutions, my lord, in the state of Assam, existing at that relevant period of time. Now, my lord, the special purpose for conducting the TET examination is arising out of an order, my lord, passed by the division bench of this honorable court in a PIL, my lord, PIL 48 of 2013. Thereafter, my lord, the government, by issuing a notification in the year 2014, this TET examination was conducted. Accordingly, my lord, around 20,000 to 500 candidates were passed out in the various category, my lord. And, my lord, in the madrasa institutions, my lord, although the recruitment process, my lord, had been initiated for manning these madrasa TET pass candidate for the purpose of their appointment in these madrasa institutions, my lord. But before completion of the selection process, my lord, some litigations were there. Therefore, the process could not be completed. Now, my lord, in the meantime, the government has come up with a policy that these madrasa institutions cannot be, my lord, sponsored by the government with the government money. So therefore, my lord, they have decided to convert these madrasa institutions into, my lord, general schools like the other schools, my lord, existing in the state of Assam from upper primary to secondary level, my lord. Now, my lord, as a result, what has happened, my lord, these 20,200 candidates, my lord, would not be appointed in these madrasa institutions. So therefore, my lord, the government initially took a sympathetic view, my lord, that these madrasa institutions or TET pass candidate can be accommodated or appointed, my lord, in the various level of the upper primary to the secondary level schools. So therefore, my lord, they have given the scope and chance that they can apply. And, my lord, this process was continuing till 2019. And in the year, my lord, 2019, by way of a notification dated 5/1/2019, my lord, the government has come up with a policy that from onwards, we are not going to recruit this madrasa TET qualified candidate. Reason cited, my lord, is that the course curriculum and the structure and the pattern, basing on which, my lord, the madrasa TET examination was conducted is different with the general level or the general TET. So therefore, we cannot equate, my lord, both these categories of, my lord, madrasa TET and the general TET. Now, my lord, the said notification, my lord, of 5/1/2019 was put into challenge before the learned, my lord, single judge. And the learned single judge, the ground of challenge was the, my lord, altogether 5 to 6 grounds were taken. And up to, my lord, legitimate expectation, principle of promissory estoppel, as well as the other grounds. And the learned single judge has negated, my lord, all the issue and upheld the decision of the government that there is no scope of interference, my lord. So now, my lord, the challenging the said order. Now we are before my lordships, my lord, for the consideration of this learned single judge order on the grounds which we have narrated in our appeal, my lord. And
Mr. AG,
Lordship may admit it and fix it for hearing.
Because
Otherwise, they have no ground because this
that's right.
advertisement of
You
2004.
see one thing, the predicament which faces them. Had the madrasas been in the state of being professionalized, their qualification was good enough to get them job as teachers on the basis of MTET acquired by them, albeit under directions of this court. But now, once you have converted them into general and you change the qualification, saying that MTET is not good enough to provide them jobs in the general schools. Just see the situation.
After that, we have conducted 2 rounds of TET in 2000 and
You mean
2021.
to say that they can acquire the TET qualification?
Yes, yes.
Many of them might have become overage by the time.
I think that is not their ground. Their ground they have not earned.
Yes, so they can always upgrade themselves.
They
That's
can
what
always
we want to
upgrade. And initially, the first step when it was for general, it was for 7 years period.
Hmm.
In 2012, when we conducted, and this particular TET was conducted in 2014,
Right.
and it was specifically mentioned for their recruitment in provincialized Madrasa
Yes,
institutions.
that is right. But then you have changed the madrasa institutions too.
All of them, most of them have already been absorbed or they got appointment in the provincialized institutions.
Okay.
And this conversion has been done from Madrasa institutions to provincialized secondary schools.
Right.
So those persons who obtain this particular degree or this qualification of
Were
MTET,
absorbed. They
oh,
continue
yes,
to
they
serve.
are continuing in service.
who are
We have
already,
not-
were already in service.
Who are
Yes,
already,
already
very few are left out.
No, no, my lord, the person who were already there as a teachers in the provincialized madrasas, my lord, the government was kind enough, my lord, not a single person has been terminated. They,
Irrespective of the fact that they are not having TET
yes,
qualification.
yes, my lord,
Because after the MTET examination,
my lord.
some must have been recruited into the provincialized madrasa.
Provincialized madrasa, and those madrasas are converted to now
Now,
regular schools.
So the government is trying to upgrade these people,
My lord,
acquire the TET qualification now,
my lord, the issue of the conversion, my lord, is now
is
pending,
now pending before
pending
Supreme
before
Court.
the apex
So
court, my lord.
ultimately,
My lord,
we'll have to decide this issue on merits,
my lord.
whether
That
the
is correct.
qualification, equivalence of
My
qualification.
lord, yes,
No, basically it is on
correct.
that.
My lord, only one very respectful limited submission is that, my lord, these madrasa institutions, my lord, if we go by the statute, the definition, my lord, these madrasa institution is situated at par with the general schools. Now, the government was kind enough, my lord, to conduct the TET examination for these madrasa institutions. So if
They
this,
restricted it that the
my
entry
lord,
would only be permitted into these very institutions.
no, that
Now
is
the
correct,
character of these institutions has been changed to general,
my lord,
whether that degree will be valid enough or would be sufficient
my
enough
lord, my
for
lord,
you to
my lord,
seek appointment as a teacher in general school.
my lord, may I
For that,
examine?
we'll have to give a finding of equivalence.
Yes, my lord. That is,
We'll have to hear.
my lord.
Admit.
Heard learned counsels. Appeal is admitted. List for hearing. All parties are represented.
My lord. May I pray for a date, my lord?
You'll get it May,
My lord.
June.
May, June.
We'll have it on 6th of June.
6th of
My lord.
deeply obliged.
Obliged.
Item number 20,
নাই নাই মই নহয় মই জানো যাবৰ কাৰণে কৈ খালী হৈ গলে বেয়া কথা হা?
Yes. There's no one. No. Okay.
May I please, your lordship, my senior is on leg at court 11, so your lordship may kindly pass the matter for the day.
Adjourn for the day.
Adjourn.
And the request of learned counsel. I think
Deeply
was right.
obliged. Thank you.
My lord, this appeal is preferred by the state.
It's a very narrow campus, my lord. The initial, my lord will just peruse the order dated 29/3/22. Passed by this honorable court, my lord. In the room,
Yes.
my lord, in the third para, my lord, we are only on the procedural aspect of the matter, as contention has been raised by the writ appellant that the impugn order was passed by the learned single judge without counter affidavit being filed by the state respondents in the writ petition. In view of the above, we stay the operation of the impugn order. And last, my lord, last line, respondent may file counter affidavit within 3 weeks. My lord, what happened in this matter? In the writ petition, this writ petition, my lord, this 6081, it was disposed of, my lord, in the motion stage, my lord, without giving us any opportunity to file the affidavit, my lord, our response. So in that thing, my lord, the matter was stayed.
Did you even pray for the opportunity?
Yes, my
Read
lord.
the order dated 22nd November 21 in the single, before the single bench, please.
Yes, my lord. My lord, 201, the writ petition, writ appeal, my lord. It is there.
Right. Carry on. We are having the original writ file with us.
My lord. My lord, in second para, I am reading the order, my lord. Mr. So and so appearing for the respondent submits that he has received instruction this morning by letter dated such and such, issued by the Joint Secretary to the Government of Assam Home Department. He submits that in terms of the dated, the suspension order of the petitioner was extended for another 3 months by notification dated 8/11/20. He further submits that he may be given 7 days time.
No, sir, read the order dated 22nd November.
22nd
November. You don't have it?
No, my lord.
Ye dena. Make any prayer before the single bench that you wanted to file an affidavit? It was simply a prayer to obtain oral instructions.
My lord, no notice was issued. So without notice, I cannot file affidavit, my lord. Notice has to go, my lord.
The appearance of the state is there. There is a procedure for supplying advance copy to the Advocate General. That is service on state. Why notice is required to be given?
No, my lord, that was the first day, this 22/11/21, I was asked, my lord, I appeared in this matter, my lord, and I was directed to get instructions, my lord. So basing on the instructions.
You could have made a prayer that we want to file a reply or a counter affidavit. You didn't pray. So even on the next date, where is your prayer? When the matter was considered at the motion stage, where is your request? Please grant us time. File counter affidavit.
My lord, on the next date, we have made a prayer, my lord.
Okay.
It is in the impugn order, my lord.
Let us. Yes. Yes. You're right.
I made a prayer, my lord.
What do you say, sir? This is not called for.
No,
They can't be condemned unheard.
no, my lord, my only humble submission is that my learned friend is very rightly put. It falls on a very narrow concept. Question is, my lord, supposing they are given time to file the affidavit. That information is already there in the letter, which is quoted in extension.
Immaterial. They wanted to file a counter affidavit. They should have been granted one opportunity.
No.
Heavens were not falling.
In an, my lord, I cannot say no to that proposition, but I only was trying to, my lord.
All information was there, we presume. But if still the state council says it's a matter of suspension of a public servant caught red-handed in corruption.
No, my lord, in the charge sheet file, he is not even named, my.
We are not bothered. That would come out from the reply. Then you would have had a better case. Even now the order is stayed. So your client continues to be under suspension. So it is better concede. We grant them permission to file reply. Let the SB consider it.
Okay.
Okay. लिखिए, the instant writ appeal is directed against the order dated 26 November 21. Hereby, comma, WBC number so and so filed by the respondent against the order dated 17/6/21, whereby he was placed under suspension, was accepted and the order of suspension was quashed. The only contention of learned, your GA,
My lord. My lord.
Mr. Dhar, appearing for the state, appellant state, is that formal notice of the writ petition was not issued in the proceedings before the single bench. The matter was disposed of at the motion stage by order dated 26/11/21. In spite of the prayer made that 7 days time may be given to file affidavit in opposition, comma, the writ petition of the respondent was accepted. This assertion of Shri Dhar is not controverted by Shri K.N. Chaudhary, senior advocate representing the respondent. However, his submission is that facts which the respondents possibly could bring on record were already available on the file of the writ petition. Be that as it may, we are of the firm opinion that providing opportunity of hearing to a party in the writ petition, more particularly the state, in a matter involving challenge to a suspension order passed against a public servant charged with corruption, was essential. In this background, comma, the impugned order dated so and so is, which is stayed by this court by order dated so and so, is hereby reversed. The matter is remanded to the writ court for fresh consideration of the writ petition. The reply public counter affidavit will be filed within 7 days of reinstitution of the writ petition.
My lord, my lord,
The appeal is allowed in these terms.
my lord. Deeply obliged.
You have filed the counter here. This is the appeal.
This may be treated as the counter.
This petition of appeal shall be considered to be the counter of the state in the writ petition.
And we have filed an affidavit, so additional affidavit that.
You may file it.
My lord. Yes.
The petition of appeal of the counter affidavit in support thereof filed in this appeal.
This is not an.
The learned single bench is requested to expedite disposal.
No, any observation in law.
We have not made any observation at all.